This is Lecture 12, Claim Construction Part 2, Interpreting Claims. So this lecture is primarily about the methodological approach of claim construction, and the primary case for that is Phillips. So we're going to talk about the Phillips case, the Federal Circuit, in some detail, and the process of claim construction, how judges are supposed to interpret patent claims under the Phillips regime. We're going to talk about whether Phillips, which was intended as a Federal Circuit decision to clarify and stabilize the law under one particular methodological approach, whether it has actually changed anything from the pre-Phillips era of confusion. The short answer there is it has not. And then we'll talk about, in light of that, in light of essentially the failure of Phillips to change things, whether we should reconsider this Markman Cybor framework for having judges interpret claims and a lack of deference and so forth. So that's the agenda for this. So let's talk about Phillips and the process of claim construction. So first, a quick sidebar. We've talked about this already in the course, but I just wanted to highlight it once again. And this is the issue of means plus function claims. Supreme Court had often disapproved functional claims for reasons that we've already discussed, which is functional claim language seems quite broad. It can be unusually vague. It offers patentees a potential opportunity to possibly game the system in various ways by claiming things in terms of function rather than structure. A response to that has been the addition of 112 paragraph 6, what is now known as 112 paragraph F, to allow functional claiming, but do so in a more constrained fashion, known as means plus function claiming. Right? And this is the language from 112 paragraph 6, which was added originally in 1952. It's been tweaked a little bit in the latest round of patent amendments, but really nothing substantive. An element in a claim for a combination may be expressed as a means or a step for performing a specified function without the recital of structure, material, or acts, and such claims shall be construed to cover the corresponding structure, material, or acts described in the specification and equivalents thereof. So claims that, or elements that are claim elements that are written in 112 paragraph 6 format or 112F format are known as means plus function elements. How are they to be construed? Well, they're construed exactly in the way the statute requires, which is you look into the specification, you find the corresponding structure, material, or acts which describes the way that function operates, and that essentially gets imported in as a claim limitation, right? And so this is quite different from typical claims where, as you will remember from talking about in the last class, we try to not incorporate too much from the specification and instead use the language of the claims to guide us. Here we are expressly required by the statute to use the specification to import a claim limitation, that being structure, materials, or acts in support of the functional claim language. So 112 paragraph 6 functions or claim elements are important to understand, and they're very common. One of the major issues with means plus function claims, and I think one of the most unfortunate aspects of this area of law, is that it's quite difficult currently to identify means plus function claims because the Federal Circuit has developed the following rules. Using the word means triggers a presumption in favor of 112 paragraph 6 or 112F. The non-use of means creates the opposite presumption. So whether or not you use the word means can create a presumption either way. The presumption can, however, be overcome if the element does or does not recite sufficient structure. And that's the problem, right? The problem is because you can overcome the presumption by arguing that you've either offered sufficient structure or not offered sufficient structure, that means it can, even the word of the use of the word means or the non-use of the word means doesn't tell you whether or not you have a means plus function claim, right? So elements without structure are functionally claimed and therefore means plus function elements. Elements with structure are not, even if they use the word means, because they have enough structure in the claim to perform the function. And because of that, it's increasingly become difficult to determine what kinds of claim elements fall within 112 paragraph 6 or 112F and what don't. Right? One example here is this personalized media communications case, which I didn't assign you to read, but you don't really need to know it. The interesting part there is that the claim element was a digital detector for receiving and detecting. Right? And the question is that a means plus function element? Right? And the court there found that it was not, in part because it thought a digital detector provided plenty of structure. But of course, saying something is a detector doesn't offer a lot of structural information to the reader. So it's an interesting question about whether or not means plus function elements can be easily identified, right? And so what happens if you try to claim in 112.6 format but don't provide structure? Well, your claim is then indefinite, right? Because you have failed Section 112, which requires definite claims, by not providing sufficient structure in the specification, right? And if you try to claim functionally, but the court determines that 112 paragraph 6 doesn't apply, you might have this problem, right? Which is that you might then have an indefinite claim because there's not enough structure in the specification, or vice versa. It could be that you are trying to claim in normal format and therefore not import structure from the specification, but the court determines that indeed you did claim in 112 paragraph 6 format, and therefore there was it uses the specification to limit your claim in a way that maybe you didn't intend, right? So the answer here, or the problem here that I'm trying to point out, is that the current doctrine is unfortunate in that it doesn't give a lot of certainty with respect to what kinds of claims are fitting into means plus function or not means plus function. Probably a better option, and one that's being proposed actually by the PTO and other academics as well, is to have essentially a check the box system, right? Where you, if you want a claim element treated as 112F, you check a box saying this claim element is 112F, and therefore there's no ambiguity about that, and you get the treatment depending on whether you check the box or not. That would seem to be a much better way to go. But in any event, that's sort of a sidebar, a little bit of a sidebar on claims. But let's go and move on and talk about Phillips now. Right? So this is a 2005 case. It's an en banc decision. And so in Phillips, the court takes the issue of claim construction methodology, how to interpret claims, en banc to resolve what it described as a serious split in its jurisprudence. And indeed, as we'll see, was a serious split in its jurisprudence, and tries to resolve it. So let's walk through the case a little bit here just to get a sense of what's going on. Right? So here's the important claim element. Means disposed inside the shell for increasing its load-bearing capacity, comprising internal steel baffles extending inwardly from the steel shell walls. Right? So the issue here isn't so much a means plus function element, right? Although you can see the word means there. The question here is what the baffles mean. And in fact, when it says baffles extending inwardly, is there a particular angular requirement of the baffles, right? And you can see the picture, the image, the drawing from the patent right there, where it shows those baffles labeled. Labeled 22 is sort of a tip of it. 32 is another baffle. These are the invention here were modular wall systems for prisons. The idea is you could sort of put these wall systems together and make temporary prisons here and there. And so you can see that there were these baffles extending inwardly from the walls. Right? And you can see the description, or the diagram here includes a bullet path trajectory diagram showing that if bullets, for example, were shot against the wall, that they would deflect as a result of these baffles. But again, the question for claim interpretation is, do the baffles have an angular requirement? And the panel, the 3-judge panel that originally heard the Phillips case, split on this question. Right? The panel majority, 2 out of the 3 judges, said that baffles must be at angles other than 90 degrees to the wall. Right? The reason they said this is that they looked in the patent specification, and the specification describes deflection as an important characteristic of the invention. Right? And they also said 90-degree baffles are part of the prior art, so it seems unlikely that the patentee wanted to include the 90-degree baffles since there was nothing particularly new about them. Right? The dissenting judge says, on the other hand, that this is completely wrong. That if you look at the actual claim language, it doesn't say anything about angles. That's the only mention right there. The baffles right there is there's no angular requirement associated with it. Right? And so the dissent says if there's no angular requirement in the claims, you can't read an angular requirement in from the specification because the specification is not the claim. And what the patentee claimed was something, that had baffles, but did not have baffles at any particular angle, right? And so this is a classic approach, a classic dispute about how to approach claim construction, right? And almost all claim construction disputes really boil down to this type of debate, which is how much information are we going to try to glean about disputed claim terms from the specification versus sticking to what the claims actually say. Right? So the dissent says, well, it may well be, for example, that 90-degree baffles are already in the prior art, and therefore the inclusion of 90-degree baffles doesn't provide this particular patent with any distinguishing characteristics over the prior art. And what the dissent says is, then if this patent is not novel, then it's not novel. And that's the fault of the patentee for claiming any angle or for not describing a specific angle. Right? Whereas the majority says, in a sense, trying to discern, using the context of the specification, what the patentee really meant here. Right? And the patentee must have meant something other than 90 degrees because the patentee described deflection and the patentee acknowledged that 90-degree baffles were in the prior art. Right? And so this is really a fundamental disagreement about how to interpret claims, and it's really about how much weight you put on the specification, right? And when you use the specification. And in some of my research, I have actually characterized these 2 different approaches, right? Which is really fundamental to understanding claim construction. And the first on the left here is what I call the procedural approach, which is really the way the panel dissent, operated in the Phillips case. And that is a focus on an ordinary meaning. So a procedural judge would say, look, it doesn't say anything about angles in the baffle. Right? Now that doesn't mean you would never go to the specification. Right? You might go to the specification if the word could not be understood. If the word baffles was so deficiently understood that you had to go to the specification to realize what it said. But that's not the case in the Phillips case, right? Often a proceduralist will say, well, let's look at what a dictionary says in terms of the word baffle, for example. If you look up in a dictionary, does it say something related to an angular requirement for baffles? And the answer obviously here is no, right? So start with ordinary meaning is the way a proceduralist would approach. And the presumption, there's usually a presumption associated with this to a proceduralist. They would say, we're going to give the patentee what he or she actually said in the claims unless there's a good reason not to, right? Now contrast this with the other approach called the holistic approach. And the holistic approach is all about the context. And the idea behind the holistic approach is that the best way to get at the true meaning of a disputed claim term is to understand it in the context of the patent document in particular, but even other things like the other prior art, related technologies, and really try and discern from the surrounding context what the best answer to the dispute is. Right? So although it's important to someone who uses the holistic approach that the word baffles isn't followed by an angular requirement, that doesn't really answer the question. Instead, what someone who follows the holistic approach says is, well, the fact that it doesn't say angles doesn't decide it, because we need to understand the context of the word baffles in this particular patent. Right? And so we need to then look at the patent document. We need to read the diagrams, for example. We need to look at the prior art, maybe get some expert testimony about what people of skill in the art would understand baffles to mean. And there, we are more likely to get to what the patentee, what the answer is with respect to what baffles means. Does it have an angular requirement or doesn't it? Right? So as you can see, these are two very different approaches to understanding claim construction. So you can actually measure, and I have as part of my research, how the court breaks down along these two dimensions, procedural versus holistic. And from the Markman case in 1996 all the way to Phillips, right? The procedural approach was the majority approach, but not overwhelmingly so. 65-35, right? About 2/3 of the time, the court, when it decided a claim construction case, would use the procedural methodology, meaning it focused primarily on the ordinary meaning of patent claim terms, right? About 1/3 of the time, it focused on the holistic approach, that meaning the context. It would read limitations that it found in the specification. It would understand limitations that way, right? And not only can you figure out how the court behaved over that time period, but by using statistics, you can actually get averages. So over time, you can track the way that the Federal Circuit was behaving with respect to this approach. Basically, the graph I'm showing you here shows you a 20-case average at any given time, meaning at any time, if you looked backwards over the last 20 claim construction opinions, how many of those would be coded procedural? The higher up the chart, the y-axis it goes, is procedural. So you can see that it bumps around a fair amount. The two lines here are, the blue line is a 20-case average, the red line is a 100-case moving average. You can see it bumps around a fair amount, but the trend from Markman through Phillips was pretty clear in favor of the procedural approach. Statistically significant trend, although not totally uniform, but a statistically significant trend in favor of the procedural approach. Right? However, a 65-35 split, right, is not good. Right? A 66-34, whatever. 2/3, 1/3 is not very good. I mean, it's not as bad as 50-50. It's not a pure coin toss, right? But it's still not good, because it meant that when parties got to the Federal Circuit, they very often didn't know how the claim construction issue is going to be resolved. And more importantly, district courts had very little knowledge about which claim construction approach they should use, because we showed statistically as part of our research that when the Federal Circuit overruled claim construction, it was almost always on the basis of this methodological dispute. Okay? So that is why Phillips was taken en banc. Right? So Phillips, the panel comes out, it's a disputed panel along this exact dimension of procedural versus holistic, and the Federal Circuit decides it's going to take the case en banc and try and resolve this dispute. Right? And so they do, or they say they do. Right? So what they use is this Texas Digital case, which is at the time probably the most procedurally oriented case, probably the sort of the leading case espousing the procedural approach. So what the court in Phillips says is the concern expressed by the court in Texas Digital was valid, meaning the concern that by using too much contextual information, you undermine the role of claim language. Right? You destroy the whole reason for having claims if you just use the specification as your set of claim limitations. The methodology it adopted placed too much reliance on extrinsic sources such as dictionaries, treatises, or encyclopedias, and too little on intrinsic sources, in particular specification and prosecution history. While the court noted the specification must be consulted in every case, it suggested a methodology for claim interpretation in which the specification should be consulted only after a determination is made. That approach, in our view, improperly restricts the role of the specification in claim construction. Okay, so this is actually something of a surprise to those of us who are watching Phillips fairly closely, because if you sort of counted noses before the Phillips en banc case, you would think they were going to come out in a procedural fashion. But right off the bat, they say we don't like the procedural approach, or we think that it's too restrictive. Right? On the other hand, right, so they come down in favor of a more holistic approach, and they say that Texas Digital did it wrong. But then they go on and say, as we've noted, we don't intend to preclude the use of dictionaries. Dictionaries or comparable sources are often useful in assisting in understanding the commonly understood meaning of words and have been used by both our court and the Supreme Court in claim construction. This is true. Okay, so what's the role then of dictionaries? Right? You'll remember proceduralists thought dictionaries were quite important because they provided an ordinary meaning of claim terms that you would then only deviate from if there was a good reason to do so. Whereas the holistic approach didn't really want dictionaries to be involved because the much more reliable source, say the holistics, is the specification. Right? And so then the court goes on to say the line between construing terms and importing limitations can be discerned with reasonable certainty and predictability if the court's focus remains on understanding how a person of ordinary skill in the art would understand the claim terms. For instance, although the specification often describes very specific embodiments of the invention, we have repeatedly warned against confining the claims to these embodiments. Right? So now the court's getting pretty confusing, in the sense that it describes a holistic approach as being the right way to go, but then says we're not saying that what you should do is use the embodiments described in the specification as confining to the claims. Well, if you're going to use the specification as context for understanding the claims, then aren't you confining, in some sense, the claims to what has been described in the specification? And the court goes on. We have recognized there's no magic formula, nor is the court barred from considering any particular sources or required to analyze sources in any specific sequence as long as those sources are not used to contradict claim meaning that is unambiguous in light of the intrinsic evidence. Intrinsic evidence, of course, is the specification and prosecution history, right? So do whatever you want, use any source you want, use it in any order you want, as long as it doesn't conflict with other things, namely the intrinsic evidence. And the sequence of steps used by the judge in consulting various sources is not important. This is a direct sort of comment on what the proceduralist said, which is you start with an ordinary meaning first, and then you determine whether or not you need to change the ordinary meaning for some particular reason. The sequence of step is not important. What matters is for the court to attach the appropriate weight to be assigned to those sources in light of the statutes and policies that inform the patent law. So is there any sentence in patent law that has less meaning than that one? Well, of course, you're supposed to assign weight to the appropriate weight to sources in light of the statutes and policies affecting patent law that inform the patent law. But of course, this is the poor suffering district court judge who's reading these words and saying, these provide no context, no information, no actual content for how I'm supposed to determine how to interpret claims. It just says I'm supposed to do it right. I'm supposed to attach the appropriate weight. The court doesn't tell them what the appropriate weight is. It says, well, the appropriate weight is that which is required by the statutes and policies that inform patent law. That's it. Right? So district courts say this is extremely difficult to know. Right? There's no content to Phillips, unfortunately. Right? So Phillips takes the issue of claim construction methodology en banc, says they're going to resolve the split, and to some degree they resolve the split. They say we're going to use a holistic approach, and then they start describing the approach, right? And the approach, and they do so in such a way that is so muddled and messy that nobody can really understand what they're saying. And to make matters worse, right? Here's a collection of things that they say at various points in Phillips, right? They say, for example, claims are ordinarily given their ordinary and accustomed meaning. Well, that's straight out of the proceduralist rulebook. On the other hand, they say claims are intended to be read as part of the specification. Okay, but that's directly contradicted by the earlier statement that claims get their ordinary meaning. Extrinsic evidence may be useful to the court, but is unlikely to result in a reliable interpretation of patent claim scope unless considered in the context of the intrinsic evidence. Okay, so you can use dictionaries, but not really use dictionaries. Right? The meaning is that which a faceta would ascribe. Okay. So you're supposed to interpret a claim in light of a person having ordinary skill in the art. Of course, that's exactly what a proceduralist would say. On the other hand, they also say the interpretation to be given a term can only be determined and confirmed with a full understanding of what the inventors actually invented and intended to envelop with the claim. So now they shift from on the one hand saying you read claims in light of what a person of ordinary skill in the art would understand, and then they say, but first you need to understand what the inventor intended to claim. And then they say patentees can be their own lexicographer. We've talked about that before. That means patentees can make their own language if they need to, create their own terms and define them as they wish, right? Okay, so very confusing. And then they go on to say dictionaries are often helpful, right? Terms are often used in their customary manner. Okay, that's fine, but it also directly contradicts a bunch of other things they said that dictionaries weren't particularly reliable, right? Because then they go on to say dictionaries are often reliable. Patentees often use terms idiosyncratically. True. So which is it? Are dictionaries reliable or are they unreliable, right? The specification may reveal an intentional disclaimer or disavowal of claim scope by the inventor. Okay, so we still read the specification, but how do we know when there's an intentional disclaimer or a disavowal of particular claim scope? Does describing baffles in terms of angles in the specification, does that constitute some sort of a disclaimer of non-angled baffles, or does that merely illuminate the general context of the word baffles, right? And again, the overall statement the court makes about how you interpret claim construction is that you attach appropriate weight to be assigned to those sources in light of the statutes and policies that inform patent law. So these statements are all from the Phillips case. Everything on this screen here is from the Phillips case, the majority opinion in Phillips. And as you can see, one of the frustrations that everyone has had with Phillips is that it says so many different things, contradicts itself multiple times throughout that opinion. But that's not even the end of it, because there's a bunch of other what we describe as canons of construction that are scattered throughout the case law that Phillips did not overturn, right? For example, claims are intended to be interpreted so as to save their validity. So we should adjust perhaps the meaning of claims in order to, for example, narrow them if the claim would otherwise be obvious or have a disclosure problem. On the other hand, claims may be construed according to the purpose of the invention. All right, so we discern the overall purpose of the invention, and then that informs our claim interpretation. Different claims are interpreted differently. This is the doctrine of claim differentiation. This makes sense, right? If you have claim 1 and claim 2, there's a presumption that those mean something different, right? Why would you have two claims if there wasn't some difference between them? Claims are construed in context with the specification. At the same time, as we've said before, limitations from the specification cannot be imported. That line between construing in context versus importing limitations is very difficult to discern. And the claim shall be interpreted to cover the preferred embodiment. Right? So again, these are canons of construction that have been thrown out there by various courts over the years, and again, our long-suffering district court judge says, how am I supposed to do this? There are so many competing principles related to claim construction, it's almost impossible to figure out what the right thing to do is. And again, the post-Phillips rules are basically that you can do anything you want, use any source you want, look at the context in particular of the claim term within the specification. You're not required to use dictionaries, but you may use dictionaries. You may provide weight to dictionaries or you may not, depending on the context. But overall, as long as you're attaching the appropriate weight given the statutes and policies that inform patent law. So the next question we want to take up is whether this Phillips case changed anything about the case law. By that I mean you will recall from the earlier discussion that the reason that Phillips was taken en banc was because the Federal Circuit identified this problem that it said with the split and methodological approaches to claim construction, and the point of having the Phillips case was to resolve that split in some fashion. And as you recall, what they said was that the holistic approach was the better approach, but unfortunately the way they describe the holistic approach leaves much to be desired. But there's still open question about whether or not Phillips actually changed anything in the case law. And because I've been doing a lot of research on claim construction and, as I noted before, characterizing the Federal Circuit's claim construction jurisprudence, we can track this. We can simply watch what the court does after Phillips. And so here's the pre- and post-Phillips results. And you can see pre-Phillips, the 65 or the 66-34 split. And then post-Phillips, 63-36. Now, not that many post-Phillips cases. This data comes from 2000 from Phillips through the end of 2009, so we would have a couple more years if we did it now, but we've updated this data and it shows, if anything, even smaller differences. So not a big difference, right? So this is pretty surprising that really, although procedural appears to have dropped a couple percentage points, there is still this persistent split. And so what if you limited your data set to the same number of cases on each side of Phillips? You'd see a little more difference, 68 procedural versus 63 procedural, but again, still a pretty significant split, right? And if you look at the trends, the 20-case lagged average that I talked about earlier, you can see where the Phillips opinion is in terms of numbers of cases in the data set. And you can see what goes on here, which is there's something of a change around the Phillips opinion, but after the Phillips opinion, it seems to bump pretty much right up back to where it went. And if you focus in, again, squarely on equal numbers of opinions each side of Phillips, you can see, again, not too much difference, right? And so if you zoom in on that particular part of the graph, you do see a fairly interesting pattern, right? Which is something interesting happens here with respect to the claim construction methodology at the Federal Circuit in the aftermath of the Phillips argument. You can see that right after the Phillips argument, there's a steep drop on the graph. What that represents are opinions issued by the Federal Circuit that are coded more holistic. the less procedural, right? The lower on the graph, the more holistic. The higher on the graph here, the more procedural, which is an interesting phenomenon because what it appears has happened here is that after the Phillips argument, the judges, of course, knew what the result was, right? And they were the only ones who knew, because you don't announce a result as a judge until you write an opinion, and it took about 6 or 8 months for the court to write the Phillips opinion. But the judges began behaving almost right away in a manner that suggested that they knew the result, and the result was holistic, right? So between the argument for the next 6 or 8 months, they behaved extremely holistically. Why would they do that? Well, they were anticipating the new rule. They were essentially following the new rules that they thought Phillips had determined. But the most interesting thing to me about this graph is that after the Phillips opinion comes out, look at how the court shoots almost right back to where it was before. And that's a bit of a puzzle. We'll talk about that a little more. But I think what may have happened there is that that's where you see the impact of the way the Phillips opinion was actually written. Is that although the court thought it was going to decide in favor of a holistic approach, the way that that opinion got written, with the open-ended language, the refusal to say that you couldn't use, for example, dictionaries, the express allowance that you could put weight on whatever you thought, whatever the court thought was the appropriate amount of weight on the appropriate sources. The very fuzzy aspects of that opinion mean that judges, and indeed litigants, can use the Phillips opinion to get to whatever methodological approach they want. And because of that, the court ends up going back to pretty much where they were pre-Phillips. Right? You can see a little bit of that in the post-Phillips way that the judges have behaved. Right? There's still a big split among the judges. Right? On the left here are judges that are more procedural. The red bars indicate their performance as authors. The blue bars indicate their performance as panelists. You can see that in general, people are more extreme when they're authors than they are as panelists. Right? And there's a wide variation, right? All the way from Judge Archer and Judge Michel on the far left end here, who are quite procedural, at least as authors, all the way to Judge Newman on the far right end, who's very, very holistic as an author and a little less so as a panelist, right? So still a very significant split among the judges. And so what was the Phillips effect? Well, you can sort of see it here. Here's post-Phillips. Here's pre-Phillips. Post-Phillips, pre-Phillips. The net is that the substantial split in the jurisprudence of claim construction remains at the Federal Circuit. Phillips had very little meaningful effect on jurisprudence as a statistical matter, and the split remains on the court with respect to how to do claim construction. Right? So there's no substantial change in the trends. There does appear to have been some sort of effect, but that effect was very temporary. Seems to be about a year if you sort of follow that U from the Phillips argument to where it peaks right back up again after the Phillips opinion. There's about a year of turmoil and uncertainty, and then the court seems to revert back more or less to where it was before. The judges are as deeply divided as they were before, right? Interestingly enough, many judges have changed their predominant approach, right? So pre-Phillips, if you lined up all the judges with the more procedural ones to the left and the more holistic ones to the right, right? And then you kept them in that order, but put the new data, their post-Phillips data, onto them, you'd see a scatter. Some of the judges stick to their guns, and some of them don't. And I think that says a lot about judging, much more than claim construction, right? I think that some judges take legal principles more seriously than others. Others like to try and reach the results that they think are the right results in a given case and worry less about the legal principles. But that's for a different issue. But again, the question here is why, right?
what's going on here. Phillips goes on to clarify the jurisprudence
of methodological approach,
but offers no meaningful change in the jurisprudence trend or even different judicial approaches.
Right?
Well, there's a few possibilities here. One is it could be just the way the Phillips opinion was written. Right? This hypothesis is judges do what they want. The Phillips opinion was either intentionally or not written in a way that allowed judges to essentially follow whatever methodological approach is desired in any particular case, and the judges do that as they see fit. And I think that's perfectly plausible. It's hard to empirically verify that, but certainly talking to judges, that makes a lot of sense. Another issue, another hypothesis, is that perhaps this is all unexpected, that maybe the court didn't realize when it wrote and voted on the Phillips opinion that it was such an open-ended and fuzzy opinion. Maybe they really expected that they were firmly tying themselves to the holistic approach, and this is all unexpected to them. They thought they were going to be able to resolve the Phillips opinion. Or the split in methodology with the Phillips opinion, and it just didn't work, right? This, again, goes back to this issue of the substantial change in the court's approach between the oral argument and the opinion in Phillips, and then a reversion of essentially back to the pre-Phillips equilibrium fairly soon after the opinion was released. Another hypothesis, another possibility, is that the Federal Circuit has become increasingly results-oriented, which is, or maybe not increasingly, but maybe just continues to be, which is to say that there's a philosophy of judging, particularly at the Federal Circuit, that their role is to make sure that the right results are reached in the various cases that come up to them and require a decision. And so under that view, claim construction is an extremely useful tool, right? Because it's very flexible. Because it's de novo review, you don't have to worry about deference to any district court fact-finding. And indeed, there's almost no fact-finding. You don't have to weigh testimony in almost any way. And yet, it's so powerful that you can reach any result. So if you think a particular claim feels like it's invalid, you get a claim construction that would then yield to or result in its being invalidated. If, on the other hand, you think a patentee is deserving of winning an infringement case, then the claim construction can determine that very easily, and with the flexibility of claim construction, courts can get to the results they want, the ones that they see fit, that they think is the right answer, the most just approach given the particular case. And there's not a lot that the law can do to prevent it. And indeed, after Phillips, even academics like me can't really criticize them for not following the law because Phillips says do whatever you want, right? So it could be that this is all intentional, and what the court has done is take claim construction and make it a very flexible tool for reaching the results that they want. Another hypothesis that is actually subject of some of my current research is that maybe this is really about patent drafting, right? And maybe it doesn't have as much to do about judges, and maybe it has more to do about the patents themselves. And the theory here is that maybe 2/3 of patents are relatively simple, right? They're relatively straightforward in terms of what their claims actually say and how much they cover. The other third are a real mess, and they're very difficult to determine what they mean. And so in the easy cases, you can use a procedural approach, right? You don't really need to resort to too much contextual meaning when it's obvious on the face what the patent claim actually means. On the other hand, on the messy cases where it's really difficult to figure out what the patent is trying to claim, what are you going to do except for dive into the specification, look for context, get as much information as you can, and do the best you can. And so maybe this is really about claims and the way that claims are drafted rather than the law itself. And as I said, one of the areas of research I'm working on right now is trying to link up various measurements of claim language to the results in the Federal Circuit and see if this
theory is indeed correct. And if so, that's important because it might tell future patentees how they should think about claiming in order to get the results that they're expecting. Another possibility is that we just need more data, right? That maybe this is just sort of a blip of the court returning to its roots for a little while, but eventually revert back to a more procedural approach. I can say now, since we've been updating this data as recently as the middle of last year, that this hypothesis cannot be the case. In fact, if anything, the court right now is more procedural in nature than it has been in any time that I've been measuring it. So I don't think it's merely a time lag issue. I think there's really something about claim construction that makes it difficult for the court to agree. And then finally, there could be various limitations of the study that maybe we're not picking something up. So those are the reasons for perhaps why Phillips doesn't appear to have actually changed anything in the case law. And finally, just a quick note about the Markman Cybor framework that we discussed in class 13. So you'll recall that the combination of Markman, where the Supreme Court said that the judge, not the jury, was the decider with respect to claim interpretation issues, right? That the issues of claim interpretation did not need to be sent to the jury, and instead they were the province of the judge. And then Cybor, where the Federal Circuit en banc, 2 years later, says that claim construction is an issue of law and receives no deference to district court decision making, meaning that it's de novo review. So you'll recollect that the reason that Markman and Cybor, at least in my view, make sense together is that the functional reasons that Markman described in terms of why we should give the Federal Circuit, why we should give the judge the power to issue claim construction decisions, was essentially because of the unique role of the Federal Circuit and its ability to create a set of rules, a mechanism, a framework for deciding claim construction. And that by allowing judges to be the primary and indeed the only supplier of interpretive information, the Federal Circuit could then create a series of rules, a mechanism, that would create what the court in Markman described as intrajurisdictional uniformity, meaning everybody would know what was going on with respect to claim construction. Right? And Cybor makes sense in that context because the best way to make and enforce a framework for claim construction is to use de novo review, meaning you can reverse any district court that strays from the particular framework that's been provided by the Federal Circuit. Right? And so you'll remember that Markman says interpretive issues, treating them as purely legal, will promote, although not guarantee, intrajurisdictional certainty through the application of stare decisis on those questions not yet subject to intrajurisdictional uniformity under the authority of the single appeals court. Again, let's give it to the judge because then the Federal Circuit can provide uniformity, right? And then Cybor follows up on that and says the uniformity passages demonstrates that the Supreme Court endorsed this court's role in providing uniformity to the construction of a patent claim, a role that would be impeded if we were bound to give deference to a trial judge's asserted factual determinations incident to claim construction. So the Federal Circuit says, yes, we need the power of de novo review because our job, indeed the mandate of Markman, is that we need to create this set of rules. But let's think about that for a minute. If Phillips shows us anything, it's that the court does not seem to be following any rules, right? I mean, if the Phillips case stands for any proposition, and it's actually pretty hard to find it standing for any proposition, except that it doesn't like the procedural approach. But if it does stand for a proposition, it's that there are essentially very, very few rules with respect to patent claim construction, and that courts are supposed to simply use all of the tools at their disposal and attach what it describes as the appropriate weight to the various sources of information provided. So I think if that's the case, it's worth revisiting the Markman-Cybor framework. If the Federal Circuit is not going to create a set of rules, a framework for allowing district courts to do claim construction in a predictable and rigorous fashion, then the court might as well defer to those district courts in the first instance. Right? Might as well let the district courts make those decisions and then defer to them. Sure, reverse them if they're seriously wrong, but use a much more deferential standard of review for conservation of resources, essentially. Right? Why have de novo review if the rules aren't even written down? Might as well let the district courts take a shot at it. If they get it seriously wrong, then it can be overruled. But unless they get it seriously wrong, let the district courts do it. At least that's what I'm thinking at this point, which is, we have gone now since Markman. It'll be 20 years in a couple of years. And we have seen this experiment with giving the court, the judges, the power to construe claims. And Cybor then follows up on that and says that this is all about allowing us to provide uniformity. But if the court has abdicated its role of providing uniformity, then I think Markman and Cybor doesn't make a lot of sense. And indeed, I think a lot of the judges at the Federal Circuit agree with me. They're having ongoing disputes right now, looking for cases to revisit the Markman-Cybor framework. There are cert petitions that get filed every year to the Supreme Court asking whether or not asking for the Supreme Court to intervene in this dispute and to revisit the Markman-Cybor framework. I think that eventually this is going to be fixed, and my guess is what's going to happen is there is going to be much more deference to district court decisions. I actually don't think that would be the right result if it was my preference. I think the court should undo the Phillips case. It should decide that the appropriate approach to claim construction is a procedural approach where you get an ordinary meaning, perhaps backed by dictionaries, that's what your claim means. And unless there's a good reason to, you don't get anything more or less. We're not going to read in limitations in the specification. We're not going to save you from yourself by doing so. If the PTO gets on board with that and the courts get on board with that, I think that after a period of transition, that would be the right way to get certainty in claim construction. However, the courts don't seem to agree with me and instead seem to be going, in a sense, in the opposite direction, which is towards a looser, more open, more contextual approach, which is certainly defensible, but I think it's ultimately not going to lead to a lot of certainty about what claim terms mean and results in a lot of litigation. So indeed, whenever I talk to people about what's wrong with the patent system, the first thing I always bring up, is claim construction. I think there is nothing that could do more for the patent system than by fixing claim construction and making it more certain so that people can actually understand what patents do and don't cover, which then allows a lot more certainty throughout the entire patent system. But that's my view on claim construction, and that is, of course, not necessarily the view of the courts or indeed anybody else. The law of claim construction is established by Phillips such that it is, although I think that within the next 5 or 10 years you're going to see that significantly revisited, at least the Markman and Cybor framework. So that concludes Lecture 12 on the approaches, the methodological approaches to claim construction. The postscript that I'd like to add here is that in early 2015, the Supreme Court issued the Teva versus Sandoz case, which, although it ostensibly dealt with the who decides issue, the issue of deference in particular to district court decisions on claim construction, I think the upshot of that is it's probably going to have a significant impact as well on the way that we think about claim construction, the methodological approaches to claim construction. So I'm going to do an additional lecture on that case specifically and talk about how it fits into the current state of the law and make some predictions as to where the law might go over the next several years. So look for that lecture as sort of an addition and postscript to the claim construction lectures here. And I'll see you next time.